Okay, good morning, everyone. The Court of Appeals is now in session.
Good morning. Welcome to the Court of Appeals in virtual session. I will mention at the outset that due to an unexpected and last-minute medical issue involving counsel in a case that had been scheduled for later in the day, we've had to reshuffle our calendar a bit. Anyone who is tuned into our live stream of these proceedings expecting to hear argument in the case of State of Utah versus Grover, you'll want to come back at 11:30. That's when we're going to hear that case. We appreciate counsel in this matter agreeing to move their matter up from 9 o'clock to 10 o'clock. And I hope that no one tuned in at 9 hoping to hear arguments in the case of Taylor versus Taylor, because we're going to be hearing those arguments now. We welcome members of the public who are tuning in to view or listen to the arguments, in particular Southern Utah University students, which counsel may or may not already be aware explains Lynn Vartan's appearance with us on the screen. She is coordinating those proceedings. So, welcome to everyone. I think counsel have participated in this virtual format before, so I won't belabor the ground rules, other than to mention that it's very helpful if we have occasion to go back and listen to these arguments, that counsel with each appearance state or remind us of their name and who they represent. It's particularly helpful if when counsel is not arguing, they turn off their video as well as muting their microphone so we can focus on the attorney who is arguing. Also, we don't have the benefit like we do in a live session of body language and looking sideways and sort of feeling the room, so that the judges don't talk over each other, ask questions on top of each other. We'll kind of give you a little signal that we have a question. We don't expect you to stop in mid-syllable or even mid-sentence, but when you can come to a convenient breaking point to take our question, we do appreciate that. As you attorneys know, often the most important part of your argument is answering the questions that the court has in any event, rather than just plowing through your prepared remarks. We've been very lucky for a long stretch. Every now and again we have a technological glitch of some sort. We are all expected to be patient, sort through that, give you the time to make up for what was missed, etc. So with those preliminaries out of the way then, unless any of my colleagues think I've missed something or counsel have any questions, we'll hear argument in the case of Taylor versus Taylor.
Good morning. May it please the court, Julie Nelson for appellant David Taylor. The parties here entered into an arbitration agreement which invoked all the provisions of the Utah Arbitration Act, including 78B 11-123, which says that the court shall issue a confirming order. The court must confirm unless the award is modified or corrected pursuant to, and then it lists the modification, correction, and then vacator statutes, which provide very limited circumstances in which a party may move a court to modify, correct, or vacate as described by statute. None of those provisions say that the district court may modify, correct, or vacate an arbitration award if it sua sponte thinks that something is inequitable. And that's where the Arbitration Act is fundamentally inconsistent with divorce law, because in divorce law, the district court always retains the authority. When the parties put a piece of paper in front of the divorce court, the district court always retains the authority to say, I don't think that's right, and to enter something different. Because of that, because the parties entered into this agreement, which invokes the Arbitration Act, that's a lot of things to keep straight. The arbitration agreement invokes the Arbitration Act, and it's not going to work, then 78B 11-107 is in play. That's the validity of the agreement to arbitrate. Under that provision, an agreement to arbitrate is valid, enforceable, and irrevocable, except upon a ground that exists at law or in equity for the revocation of a contract. That's what we have here. We have both at law and in equity for the revocation of contract. Just Shane.
Ms. Nelson, I take your argument as far as child custody and child support goes. I'm a little unsure, though, about the alimony part of it. It was my understanding that parties can waive the right to receive alimony in Utah. Am I wrong on that?
Well, the judge still needs to approve it and say that that's acceptable. Divorcing parties can enter into agreements. Certainly. They can go to mediation. They can enter into agreements.
Right. So if the parties waive the right to receive if one of the spouses waives the right to receive alimony at all, if that's permissible under Utah law, and as I understand it, that's done under contract principles, if a party can waive the right to receive any alimony, then why can't the party waive the right to have the judge determine alimony?
Well, hold up. The parties can waive the right to receive alimony, and they can put that in front of the judge, and the judge has to retain the ability to say that's inequitable or equitable. The judge still has to approve it.
Okay, so let me ask you a more particular question then. What about prenups? Are prenups binding, or are they not binding?
Well, prenups are not actually entered into between spouses, right? And so, they're not already spouses by definition. But you can't marry or divorce in this state without the government approving it. And so prenups are binding. Other contracts can be binding, but the district court has to stamp it first to say that it's binding. And before it stamps it, it has to have the ability to say, I don't think this is right. And that's here. The Arbitration Act doesn't allow that.
So if the parties have a prenup and then they get married and then they get divorced and they bring the prenup to the court, is your position that the court has to give deference to the distribution terms in the prenup or not at all?
Deference, but it can override it if there's an equitable provision. I believe that we have case law that says that. But when we're talking about any contract that's entered into during the course of the marriage, certainly into the actual divorce decree itself, which is what we have here, then parties cannot just enter into a contract without the district court approving it. The prenup is different in that way, but the divorce decree cannot just be entered without the district court's approval. And when the district court approves something, it has to have that ability to say, I don't think this is right. Now, in practice, they often approve them. But one situation that you already mentioned, where it happens a lot, that the court will reject it, is if the party stipulates to some random amount of child support, and the district court will say, that's not right, you have to follow the tables. Or the district court retains the equity provision in case the parties have not been able to deal at arm's length, which is often the case in a divorce. If people have entered into provisions, maybe one spouse was really treating the other spouse poorly, and that's why that contract got entered. The district court provides that gatekeeping function to say that's not okay, but the Arbitration Act doesn't have that. The Arbitration Act only allows the district court to change an arbitration award on motion of the parties and only for specific limitations. So we have two different provisions, that the district court sua sponte can do it and on the basis of equity. Does that answer your question?
Maybe, but I'm curious Judge Warren's question. So.
Well, I have to tell you, Ms. Nelson, as usual, your brief was exceedingly well done. But the whole time I was reading it, I was thinking, how is this not plain error? And if it's not exactly plain error, how is this not something that should go the way of judicial estoppel, or I guess more technically quasi-judicial estoppel, in that it was your client who sought this alternative dispute resolution remedy in the interest of moving the case along. And this may be the cynic in me, but I've got to tell you, I think if everything in the arbitration would have gone exactly the way he wanted it, he came out just swimmingly well, I don't know that he would have appealed saying, you know what, in good conscience, I can't accept this very generous treatment from the arbitrator because upon further reflection, the arbitration agreement was illegal. I mean, and I know I've just thrown a lot at you there, but some package of estoppel, plain air, sour grapes, I find very much entering my thinking about this, and I realize that's more of a little speech than a question per se, but if you could address those few concerns, I would very much appreciate it.
I do think estoppel is the correct lens for your question. The other side argued invited error, and I don't think that's the right doctrine. Estoppel is closer to the right doctrine. But we do have a lot of contracts in this state that people enter into and turn out to be unenforceable. In fact, the Supreme Court just a couple weeks ago in Kiernan reminded us that a contract to waive a statute of limitations is unenforceable. We have lots of examples bordering from the mundane to the extreme, like a contract for a hitman is unenforceable, and everything in between. I think that the statute of limitations case is helpful because it's a contract with a judicial overlay. It's getting around a judicial provision like a statute of limitations. And that's what we have here. You cannot contract around the district court's ability to review the decree for equity. Now, would my client have appealed if everything had gone well? I mean, probably not, right? Nobody does that. But it's the same as, let's say the parties stipulate to a custody evaluator. And then the custody evaluator goes and gives their report, and it favors one party. The other party can still challenge it to the district court and say, that's not right, even if they initially entered into a stipulation to get a custody evaluator and even to get this particular custody evaluator. So I think we see that happening in other areas of divorce. The parties agree to something, one person's unhappy with it, that person appeals. Here, you can't just appeal on the basis that the custody evaluator got it wrong because we're locked into this arbitration agreement.
I mean, this does seem to be a little bit different, though, because he's not just complaining about the results of the proceeding. He's complaining that the proceeding itself was illegal. I mean, so to come back to your counter hypo, it would be as if one party had said to the other, hey, let's go get a custody evaluator. And then after the custody evaluator gave the decision, that same party then said, actually, you know what's illegal? Getting a custody evaluator. That's illegal. It does seem to be a little bit different to me.
Okay. But the Arbitration Act acknowledges that in 107, acknowledges that some areas of law simply are not available for arbitration. And that's why it says, valid except upon a ground that exists at law or in equity for the revocation of a contract. And that's what we have here, because the Arbitration Act is incompatible with divorce law. Therefore, you have this ground that exists at law or in equity. And let's not forget that we did challenge one part of the arbitration award. That part that we think is an error of law, we challenged that. But because it was an arbitration, we had to go through the provisions of the Arbitration Act, which is the vacater provisions. We can't just say we don't like these findings or we think you've made an error of law. You have to go through the arbitration channel. So in that way, arbitration is different than a custody evaluator. We never think that the custody evaluator is going to be binding, but the Arbitration Act sets itself up to be binding.
Can I ask you a question about the imputation issue? I know your time's expiring, but before you metaphorically sit down, can we talk about imputation for just a little bit?
Yeah.
Is it your position that the decision maker on alimony, whoever it is, the arbitrator, the court, whoever, has any discretion at all to consider the motivation behind the job switch, or is motivation just off the table as far as an appropriate consideration goes? Well,
I think the case law actually answers these questions. If we look at, I think, two cases that are particularly helpful are Connell versus Connell and Petrozelka, maybe we should say, versus Goodwin. In Connell, we're looking at paragraph 16. It says that the purpose of such imputation is to prevent parents from reducing their child support or alimony by purposeful unemployment or underemployment. Now, it doesn't have to be, I don't think that case says, that a party has to say, you know what, I'd really like to lower my child support, so I'm going to get a crappy job. The point is that what you can earn affects your child support and your alimony, and therefore affects your children. When we look at Petrus-Vilke in paragraph 10, it says, all else being equal, a spouse who is capable of working ought to be accountable for meeting his or her own needs to the extent of that capability. And then it cites a case, and the parenthetical says, explaining that imputing income to a spouse holds that spouse accountable for meeting her own needs to the extent she is capable. So we don't really have an intent provision there. I mean, if we could just say, well, parties can, work at the job of their choice, or whatever the language was here, that's going to upend all kinds of analysis.
Right. See, but the word capable came up in both your quotes and in your description of the case law, and that's where I'm a little bit hung up on your. I mean, I think your argument it's well made. I'm just thinking through the implications. If what we're saying is that if the party is capable of earning X, then that's what we're going to impute, and that feels an awful lot like we must go with the highest possible income. But you sort of pushed back in your brief and you said that's not what you're arguing. But I don't know how that isn't your argument if what we're focused on is what the party is capable of earning.
Well, typically what happens is you get a vocational expert report that provides a range that says, I think they can earn between this and this. And then the judge has discretion to operate within that. Now, again, the judge could reject the vocational expert altogether, but there would have to be some finding of fact as to why that range was incorrect. Here we are so far below the range that if we were in a normal appeal, I would be arguing that we have an error of law for failure to consider the factors and failure to follow the case law, and an abuse of discretion for being so far below it. What we have here is just truly lower than her capability.
But I mean, just to push back just a little bit, if this is discretionary with the district court, and if I've got it right, the alimony determination is equitable in nature, so there is a discretionary component with the district court. Then why do we take off the table the ability, as part of that discretion, to look at what's driving the employment decision? I mean, I'd be totally with you if the record said that the party is trying to take this lower-paying job for some sort of nefarious reason or some, trying to play with the alimony award. But if there's some reason to think on the record that this is truly a job that the party wants, and we're saying that this is a discretionary decision, why can't that be part of the discretionary decision? That's what I'm saying.
You're sort of losing volume. Can you hear me?
Yes.
Oh, I can hear you better now.
Okay, sorry about that.
That's okay. Okay.
Bottom line, why can't, if this is discretionary, why can't the party's motivation be part of the discretionary calculus?
Well, let's imagine that the breadwinner said, just right around the time that they separated, the breadwinner said, I don't really feel, let's say my client had said, I don't really feel like working at Morgan Stanley anymore. I think I'd like to be a teacher. I think that the other side would think that that was not going to work, that was going to harm the children, and it was going to harm the alimony, it was going to harm the standard of living, and it wouldn't matter if my client had just said, I really would like to be a teacher. Or what if my client had said, I'd like to retire? I mean, that is not what our case law says, certainly regarding the breadwinner, and I don't see any reason why the recipient of alimony or child support should be treated any differently, considering that child support is for the children, and alimony goes to the standard of living. Otherwise, you just shackle the other spouse by saying, all right, well, you're not earning as much as you could. You'd like to work at Starbucks. So I guess your husband's just going to have to pay you a lot of money in alimony. That's not equitable to him either.
Ms. Nelson, would you address this? As Judge Penny was asking his excellent question, I found myself thinking in terms of, well, you're right. Whether or not to impute income is absolutely a discretionary call with the district court. However, if the court determines to impute income, then it must strictly follow the statutory requirements for imputation, one of which is not demonstrated preference to pursue a new career. Exactly. Is that, am I on track with that, or is that not your argument?
Exactly right. The choice to work in your field of choice, or whatever it was. is absolutely not in the statute, and it's absolutely not in the case law. No case law says that, parents can just work wherever they want, and especially they can take a really low-paying job around the time of divorce, and, the other ones just take care of it. That is not in the case law.
One last question then on this, and I promise I'll drop it. What if there had been record support? What if both sides agreed that during the course of the marriage she had been saying, what I'm going to do when I get into my 40s is I want to become a teacher. And everybody sort of knew that was the end game. Would that be different?
No, I don't think so, because the case law, again, talks about what is she capable of earning. And in 2015, I think, she had been earning like around $50,000, and then very shortly thereafter, she dropped significantly. And that harms her children financially. Now, if she wants, I'm not saying she can't be a teacher, right? She can be a teacher. It's just that she needs to be accountable for however much money she could make as at her earning power, at her regular earning power, and that's what the child support and the alimony are going to be based on. She can have whatever job she wants, and she can run whatever deficit she wants. She has the assets to do that. Completely fine. It just isn't baked into the income analysis.
So you would have the same answer then with respect to your hypothetical about what if your client decided, never mind Morgan Stanley, I'm going to be a teacher, and it wouldn't matter if his rationale was not, that way I'll pay a lot less money, but rather, you know what, I've been working too hard, long hours, ridiculous, that big income comes at a price, and now that I'm getting divorced, if I become a teacher, I can be on essentially the same schedule as my kids, I'll have my summers free, I'll be available for them. This isn't all about the money, this is about me freeing up time to be a more available parent. Your answer is great, and God love you, but that's on your dime. You're still going to be imputed income at $1 bazillion a year as you pursue your teaching certificate.
Not only is that exactly my answer, that's the setup in Minor, where Dr. Minor had been an anesthesiologist and had been making $1 million a year working around the clock, and once he gets 50-50 custody, he says, I can't work these hours anymore. This court said, too bad, buddy, you have to be imputed at that amount of money.
I want to push back on that a little bit, because I think there was some evidence in the record that suggested he could be the parent he wanted to be, even while continuing to work at that rate. So I don't think it was quite as extreme as you suggest.
That's fair, but that's not what we have here. We have her wanting to work at the job of her choice. And let's keep in mind that when she was earning that $50,000, she was working part-time. So she's earning twice as much money working part-time as she now is working full-time. I mean, if she had pitched an argument that it was better for the kids, we would push back on that, but maybe it's not. But that was not even part of the discussion. It was just that she wanted to be a teacher.
Can I ask you about the factors? Because the factors don't exactly tell a district court how they're supposed to evaluate them. For example, talking about employment opportunities doesn't say you're just supposed to decide what job is available. You consider maybe all of the kind of extraneous factors that relate to that, right? Why someone might want to work, what kind of time it will take, whether it will take time away from the children, which would require more child support perhaps. And then similarly, the ninth factor in Piece 9, it's other employment barriers and background factors. Background factors, I'm not exactly sure what that is, but that sounds pretty broad to me. So I'm trying to figure out why it is that you see that these factors necessarily are just really absolute. For example, age. You consider age, but that can't really be considered in a vacuum, right? Someone is 47. What does that mean? How does that affect what's going on here? So I want to push back a little bit and get your response to how it is that these factors can't be considered a little more broadly than you suggest.
Well, in Christensen versus Christensen, it talks about how these factors should be considered, and it says that we need to make findings about it. Now, I think you're right, Judge Pullman, that a court has discretion within those factors, but they have to make findings about them, and I think they certainly need to make findings when we're talking about imputing somebody a much lower wage than they historically have been earning. But we don't have any findings here. The arbitrator did not make findings. The only finding is that she wanted to be a teacher. That doesn't follow the statute at all, and that's why we've argued that it's an error of law.
One more question about this issue. You point out in arguing that arbitration can't work in this context, that it's a really high burden you have to meet in order to be able to show that the arbitrator not only got the law wrong, but disregarded it, right? Which suggests, I think, what is it? I mean, you think something nearly impossible to prove.
Very difficult.
All you've given us in support of the fact that this arbitrator willfully disregarded the law here is an affidavit from counsel which just said, I discussed the law with the arbitrator. Can we take from that just simple statement, I discussed the law with him, can we infer from that that the court truly understood everything you're arguing to us now in appeal, pointing out to us cases that existed after the arbitrator made his decision, and discern from that this arbitrator understood everything you were saying and willfully disregarded it?
Well, let's keep in mind that one of the provisions of manifest disregard, well, let's back up and say that given how challenging this is to overcome, that really solidifies the main argument, which is that this isn't going to work in this context. But to your question, one of the provisions of manifest disregard is that the error should have been obvious to anyone who was qualified to be an arbitrator. Judge Christensen had been a trial judge for like 15 years and specializes in arbitration and mediations in family law cases. Imputation of income is not obscure. It's not an unknown area of the law. There's a statute on point. There's dozens of cases on point. I think the error should have been obvious to arbitrator Christensen. And then coupled with the affidavit saying that we discussed this, because the arbitration wasn't transcribed, I don't know what else we could have done to say that this was discussed. So between arbitrator Christensen's experience and the affidavit,
I mean, she could have had in her affidavit, I discussed this law, I discussed this, I explained this to him. She even attaches a bullet point of things she discussed, but it has nothing to, there's no discussion in there of the law. So, I mean, I just think I'm curious. I guess I'm suspicious that perhaps you haven't met your burden on that point because we don't know what he discussed as far as the law. And just all of our questions about imputation, I think, suggest this area of the law is not just crystal clear. It's not obvious exactly where a district court can go in exercising its discretion.
Well, so first let me push back and say I think the law is crystal clear that a person's desire to work in a low-paying profession when they're qualified to earn more is crystal clear. They can't do that. Okay, so with that, then I think that arbitrator Christensen should have known that, and coupled with the lawyer saying, look, I discussed it with him, I think that is enough. But if it isn't enough, it just shows why an arbitration doesn't work in the divorce context, because a divorce court should be able to sua sponte say that's not right. Now, we gave the district court the opportunity here, and the district court affirmed on the basis that it was reasonable, but that's not correct. It's not the standard, nor, in my view, is it reasonable to just avoid any analysis of the statutory factors. I guess the point being that this just goes to the reason why an arbitration is okay in many civil contexts. And a divorce is civil in the sense that it's not criminal, but it's different than most civil contexts because the state is so involved. The state doesn't care if you make a property contract with your cousin or whatever. That's not a problem. The state does care about what kinds of contracts we make in the context of divorce. I will not reserve any remaining time for rebuttal.
Well, Ms. Nelson, in fairness, you did use about 3 times as much time as allotted to you. However, responsibility for the fact that you went over it lies primarily with Judge Tenney and myself, with a little assist from Judge Pullman at the end. So we will, as is our occasional custom, give you all of your reserved time for rebuttal. And we will now hear from the other side.
Good morning, Your Honors. This is Bo Olson on behalf of the appellees, Ms. Taylor today. So I think while the topic's fresh on imputation, it seems like that's an interesting factor that the judges would like to discuss today. So I'd just like to give a little bit of analysis there. When they talk about the arbitration award not going into the factors listed in 78B-12-203, that's just simply not correct. If you look at the record on 516, the arbitrator, Judge Christiansen, actually went into almost all the factors, if not all the factors. He He considered her age. She was 49 years old at the time. He considered her work history as a pharmaceutical sales assistant and also an assistant to a company while she was working in Park City. He considered her current job at the time when she was working as an aide to the park. Yes.
But is Ms. Nelson right that there isn't a factor that allows the court to consider motivation? I mean, where is that in the list of factors?
So I think if you look at factor 9, and Your Honor's already talked about it briefly, it's the background factors. I think it's important for the court to know that she wasn't working nearly close to full time when they were in the marriage. This divorce was filed in 2017, and I believe that her last W-2 that she had was in 2015.
So if the statutory term is background, and we're then going to look from that into a party's motivation, that seems awfully broad to infer that from that single word.
Well, I think background factors go into a lot of the things that she was doing at the time during the marriage. She was actively involved in the children's schooling. She was participating there, and that was something that she wanted to do, and that's something that she endeavored to do. So at the time of the arbitration, she was already working as a school aide. She was already going to get her bachelor's degree to be able to teach. So that background factor, or maybe an employment barrier getting her into teaching for the Park City School District, I think it was accurate that Judge Christiansen or Arbitrator Christiansen took that into account. Do I think that it could also go into occupation qualifications? That's another factor that it could go into, because just having a desire to work in a certain field doesn't mean that's the only way that Judge Christiansen was looking at it. What he was looking at it was in consideration of all the other factors, such as her work history, occupation qualification, education and payment, and particularly, I think, what her background factors did. Yes, sir.
So then, let me just ask you the question posed by Ms. Nelson's counter-hypothetical. What would have happened here if husband had decided that he really didn't want to be a financial guy anymore and that he wanted to be a teacher? What happens?
Well, I think the benefit that you have of this situation is Mr. Taylor was the breadwinner during the marriage. He had a long work history during the marriage. And if you look at what was equitable during the marriage, it was him working and providing for the family. Now, by contrast, Ms. Taylor never worked, at least not full-time or not during the marriage. So I think this goes back to the Connell case where it says, although an imputation can occur, the court doesn't require them to do it. It just gives them the ability to do so. So if you're balancing equities in the context of a divorce, it would be more equitable, in my opinion, to ensure that the breadwinner who's been working for 30, 40 years is imputed to somewhere near his highest earning ability. And I think it's important to look at the arbitration award. He wasn't imputed to his highest. It was averaged based on his Social Security earnings, and also it was taken into account that he would eventually lose some book of business and not work as much. So that was also an equitable consideration that Judge Christiansen took into account.
Correct me if I'm wrong, though. The statute itself doesn't draw a distinction between the breadwinner versus the non-breadwinner in terms of the imputation rules, does it?
It doesn't, but equity does, and I think that's why the case law says that the court's not required to impute income. It just gives them the ability to do so. Does that answer your question there, Your Honor?
Yeah, I think about it. Yeah.
Okay. So when you look at all these factors, to be able to say that Judge Christiansen ignored these factors or didn't consider all these factors, that's just simply not the case. I think he balanced the equities. I think he balanced the rules that the parties had in the marriage, and as a result, that's why he came out with the imputation that he did. And again, he wasn't required to impute any income if he didn't feel that that would be equitable, but nonetheless, he took her opportunity that she was earning at the time, and then once she would become a full-time teacher, she started to earn $55,000, which is only $10,000 less than what the vocational assessment said she could earn. And then he dropped alimony based on those numbers and also dropped child support based on those numbers. So that was all equitable considerations. Yes, Your Honor.
I don't remember anything in the record, and I apologize if I missed this, but was the arbitrator acquainted with the ancillary benefits of being a full-time teacher as opposed to a part-time pharmaceutical rep? I guess I'm thinking in terms of superior medical benefits, better than decent retirement package, etc. Was that any part of his consideration?
I don't know if that's in the record. I'm sure it was possibly discussed when he was in those private meetings, but I don't think anything in the record would reflect that.
Thank you.
Any other questions on the imputation of income? So what I'd like to move on to, I think the big question that we have to answer today is what type of ability does the court have when it comes to accepting arbitration agreements? Yes.
On that point, can you start with the invited error claim that you've raised before we get to the merits, which I do want to get to the merits. But you raised invited error, and let's just go right to the question. Ms. Nelson responded in her brief and said an invited error doesn't work here because he never says anything to the court saying that he thinks arbitration is okay. Why is he wrong with that?
Well, I think when I went through the record, I got to be honest with the court. I couldn't find anything in the record where he specifically said to the court that arbitration needed to happen and he wanted it to happen. I think if you look at the arbitration agreement and the procedural history of the case, the parties did stipulate to go to arbitration and it wasn't court-ordered because obviously divorce cases can't be court-ordered to go to arbitration. But I think that's beside the point that she's saying because he didn't make an affirmative affirmation to the court that arbitration should happen, that he just merely suggested it, I think that's beyond the mark. I think we have judicial estoppel, like Your Honor's talked about before. I don't think it's equitable, nor do I think it's fair for somebody to come in who really wanted it to be arbitrated on December 18th, 2018 to get the benefits of the alimony deduction so he could pay less on taxes. And then when the arbitration award didn't come out to what he believed was his favor, he just throws up his hands up in the air and says, oh, this isn't fair, this is illegal, I'm done with it. So do I think it's invited error? Yes, I do. He maybe didn't make an affirmation to the court on the record, but the collateral documents such as the arbitration agreement do show that. Yes, Your Honor.
I do think that it seems unfair. I mean, I appreciate that argument, but I think as a doctrine, invited error not only would require some affirmative assertion on his part, but also error by the court. The court didn't send us to arbitration, right? The parties just did that on their own. So, I mean, I think don't we need an error by the court in order for that doctrine to apply?
But I think the error would be if Your Honor's reverse this today, then that's the error right there. And so then I think the invited error doctrine would be up on the appellate court level because it eventually got reversed based on his affirmations to the court that arbitration would be appropriate.
Well, it would be reversed because the court erred in concluding that arbitration was appropriate. But as far as not even being able to bring the claim, I think we'd have to find that the district court sent the case to arbitration. And Lisa, correct me if I'm wrong, the court didn't do that, correct? It wasn't, like you said, it wasn't on order of the court.
The court did not order them to go, no, but they, I guess they did sanction it by their agreement. But I think that if we're talking about invited error doctrine, because there wasn't an affirmation to the court, I can concede that it's probably not our strongest argument here, although it does seem inequitable.
So let's talk about the merits of that argument. You say in your brief that if the arbitrator failed to equitably distribute property, that the district court would not be required to accept the award. Help me understand how that's the case. How could a court step in here in the context of an arbitration and change the award based on the court division of equities?
Sorry, can you just repeat that one more time? You broke up just a little bit there.
Sure, I apologize. So help me understand how a district court here would have the authority to come in and look at an award and say, I don't think this is equitable. I just don't think this is fair, and so I'm going to reverse it. What under the Arbitration Act allows the district court to do that?
So one of the things that Ms. Nelson brought up is she says the court may never issue their own motion, that they can't do anything sua sponte. And I've looked through the Arbitration Act extensively, and I have not seen anything that specifically excludes the court from being able to do that. And so if you look at Hansen v. Hansen, and this is a case that I found based on her rebuttal, and if you'd like to cite it, I can give it to you, that it's the 2020 case with the Court of Appeals. And one of the issues that court addressed was a judge made a sua sponte motion, and the court found that, and then the appellant said that was inappropriate. And what the court said is the appellate court said the court always maintains the ability to have their own case and file their own motions if it's necessary. And it's only when the parties don't have an opportunity to respond to that, or their due process is violated by not having an opportunity to respond to that, does that become an issue. So here, if you look at the Arbitration Act, I don't see anything in the Arbitration Act that specifically excludes a court from issuing a sua sponte motion. But, yes.
I assume that Hansen case was not an arbitration case, correct?
No, it was not an arbitration case. But, like I said, I don't see anything in the Arbitration Act that says the court specifically cannot issue a sua sponte motion. But when it comes to how the court can correct that, it is an interesting question that Ms. Nelson has brought up. But I think it goes back to one of two things if you look at it. Yes, Your Honor.
Okay, so one of the things that she's brought up, and I suspect this is where you were going, I apologize if it wasn't, she says that in order to overcome an arbitrator's award, you have to show that the arbitrator, quote, demonstrated a manifest disregard of the law. Is that right as a legal principle? Is she right about that?
Yeah, I think it's more than that. If you look at 78B 11-124, there's a whole list of ways that you can vacate the award, but that is one of the issues. That's one of the areas that you can.
Okay, and that seems, just going globally, it seems like the whole point of going to arbitration is to make things non-reviewable. This is the benefit of arbitration. As you go to the arbitrator makes this decision, you pull it out of the judicial process. But once you've gone that track, it's harder for the judges to come in and review it. And I take Ms. Nelson's point to be just that, is that that's just not a fit with what's happening with domestic orders, that the whole point of domestic orders is that they have to be reviewable. Why is she wrong about that?
So I think there's two things. I think a lot of the case law that she's relying on is it never says anything about arbitration awards. It simply talks about stipulations. All the case law, at least the majority of the case law that she says, that stipulations are only a recommendation to the court, right? And so I think arbitration is a little bit different here. Most of the people in divorce cases go to mediation or they reach a stipulation on their own regard. There's no statute, there's no case law that I'm aware of that makes mediation ever mandatory, nor does it make it ever binding. However, we do have the Arbitration Act, and that's a little bit different here. We now have a judicial legislative act that says, if the parties agree to it, and if they contract it for it, because like you were talking about prenuptial agreements and just marital contracts in general, they're held to the same standards as any other contract. If they go into that, they waive certain rights when they go to arbitration. Now, arbitration is different as well because it is binding for the most part, but the arbitrator is generally somebody who is trained in the law, who understands the law, and where you could get the same benefit of going to court by going to arbitration by getting it done a lot more efficiently and a lot more quickly. So do the same safeguards need to be there as they are for stipulations? I would say no, they don't, because the arbitration takes those things into account. They're trained in the law, they analyze the law, they know the law, and they apply the statutes based on what they think is appropriate. And then, at that point, you have the safeguards that are missing from stipulations and other mediated settlements.
Yeah, I think that's probably true in most cases, but I think the response from the other side is that the only way to really know if the arbitrator got the law right is for some other judge to come in and review it. And if the fact that it went to arbitration makes it harder for a court down the road to review it, then you've now taken this thing out of the judicial process that by statute and by longstanding policy is exclusively within the judicial process. So how does that work? How do we have a system in which somebody other than a judge, for example, can decide who gets the kids? Or how do we have a system where somebody other than a judge gets to decide how to split up the property? I think that's sort of globally the problem that they're pointing to.
And I understand the problem globally, but for these set of facts, I think it's quite narrow. We have a lot of case law, like the Sweet House, the White House case, et cetera, and the Weaver versus Powers case, where the court isn't ever going to come in and save somebody from the benefit of a bad bargain or something that they don't think is fair and equitable if the documents provide that they signed it knowingly and willingly. And your questions about, for example, child custody and things like that, that's a whole different issue that's not before the court today because those weren't the facts of this case. The fact is that...
Can I ask you that question pointedly? Would it be your view that child custody orders can be arbitrated or not?
I think that creates a lot more difficulty for child custody orders to be arbitrated just because of the principles of equity and things, just for the best interest standard, because that's a little bit more judicial review that needs to happen because we are talking about kids and really, really important decisions for the parents. But here, we're just talking about finances, which is something...
Same question then on child support. It feels to me like we've got something of a spectrum, and we've got custody, which I think you correctly recognize would probably be different. But the child support seems to be in the same boat too, though, because it's a right that belongs to the child as opposed to the parent. So can a child support order be arbitrated?
I would argue that it could because the case law, the law on child support is extremely clear. All you have to do is figure out how often the child is going to be at one parent's house, the income of the parties, you stick it in the calculator, and it spits out a number for you. There's not a lot of legal analysis, and there's not a lot of legal argument that goes into child support awards, because it's just numbers, it's just income. There's not really much that needs to be argued there. So yes, I do think a child support award could be arbitrary, and I do think it's subject to appeal based on 129 of this Act. Yes, Your Honor.
But in order to set those numbers, you have to figure out the incomes of the party, like you just mentioned. And doesn't that require a lot of balancing the factors and considering evidence? I mean, that's not just a calculation, correct?
It's not just a calculation, but for the majority of people, they're just W-2 employees, or a lot of people are unemployed, which means the statute says an MG to at least minimum wage at $12.56. I guess a few people, it could become more nuanced if they own their own business or their income's not as clear. But I still think that's something that the arbitrator, based on his experience, would be able to calculate and be able to come to a number where child support could still be effectively calculated. Well, I see that my time is up, so if there's any other questions, I'm more than happy to answer them. If not, I'll submit on that. Thank you.
Thank you very much, Mr. Olson. We'll hear again from Ms. Nelson.
Always forget to say my name again. Julie Nelson for Appellant David Taylor.
Thank you.
You're so welcome. I think that the place to focus here is at the beginning of our brief on pages 14 and 15, where we talk about the extensive case law about how agreements between parties, not just settlement agreements set in mediation, but agreements between parties serve only as a recommendation. And district courts always retain the power to disregard that. That's true in alimony, child support, custody, parent time, and property rights. Now, I can agree with Judge Tenney that we may have a spectrum here with property rights on one end and, let's say, custody on the other end, but the entire spectrum is on the side where the district court has to retain authority to set it aside if it thinks it's inequitable. I mean, we even see it in property rights, which I think are the ones that people would think maybe could be arbitrated. But the case law on property rights is the same. At the bottom of 14, we quote Reese, which says, agreements between spouses to fix their property rights are generally not held to be so absolute as to prevent a court under its equity powers in divorce actions from doing that which justice and equity require for the interest and welfare of the parties involved. And the Arbitration Act simply doesn't allow that. A district court cannot set aside an arbitration award to do that which justice and equity requires for the interest and welfare of the parties involved.
See, I'm a little bit stuck on Reese, though, because there's other language in Reese that seems to push back at least a little bit. I mean, I'm looking at paragraph 24 of Reese, and the court said, quote, we have explicitly acknowledged the general authority of spouses or prospective spouses to arrange property rights by contract that is recognized and enforced by a court in the event of a divorce. I mean, you're right. There's then the language in paragraph 25 that talks about the court's equitable and statutory duties. And it comes back to the dialogue that you and I had earlier. If you've got language in Reese that talks about the party's ability to contract about property, then I'm struggling what to do with this hypo. Let me just ask the hypo. What happens if you got a situation where husband and wife are both savvy players? They're both represented by counsel. They have this good faith negotiation. They say, if we get divorced, here's what happens to all the property. Here's what happens to alimony. They get divorced. That contract comes to the district court, and the district court says, I just don't like the agreement. And the district court really throw that out, or is the district court bound by the agreement?
Are you still talking about in the prenup context?
Sure, although Reese talks about spouses or prospective spouses, so it seems to contemplate the both can do it.
Okay, well then Reese answers the question, right? That the trial court can set it aside on the basis of equity. And that's because it doesn't want to just leave one person with nothing. That equity argument is always available. It's even available in distributing separate versus marital property. Somebody comes into a marriage with all this money. The trial court, there are certain ways in which that person can commingle. But there's still the equity door that the district court can use. Now, does it use it very often? No. But we cannot shut it off. That's what the case law says, is you cannot close that door. And if you cannot close the door for an agreement to be treated differently than a recommendation, that wasn't a very clear sentence. Agreements are always recommendations. You cannot make it different. And if you cannot make that different, then an agreement to arbitrate is in the same category. You cannot. I think we can look at the custody language. It's still true. Parties cannot stipulate away the district court's statutory responsibility to conduct a best interest analysis. That's the strongest, but it remains true even in the other things. The law was intended to give courts power to disregard the stipulations or agreements of the parties in the first instance. I'm sorry to read from our brief, but that's where all of that case law is laid out. It's very clear. You just cannot do it. Even if, and I just want to be clear that I think that the legislature could fix the problem. The legislature could say that arbitrations are treated as recommendations in the domestic context, just like everything else. That would solve the problem, but that's not what it currently says. There are no further questions. We would ask this court to reverse and hold that divorce cases are not subject to arbitration. Accordingly, this arbitration agreement was unenforceable and return it to the district court for an analysis of the outstanding issues.
Thank you. Mr. Olson, will you join us again on screen? Our final little concluding remarks here. We do appreciate the arguments from both sides. As you know, we don't schedule argument in every case, only those where we think that argument will be of material assistance in our consideration of the case, and that definitely is the situation here. I at least feel like our time was very well spent and appreciate the arguments from both sides today. As is our custom, we will take the matter under advisement and let you have a written decision as soon as we're able to get that done. With that, we'll be in recess until 11:30.
Thank you, Your Honors.
Thank you.
Okay, well, for us in our audience, that was the conclusion of the first case. We will be back for the A.P.E.X. Official event at 11:30, and that case will happen in very much a similar way, although we will have a Q&A after for any remaining time in the hour, where I'll start with a couple of questions, and if anybody from the audience has questions, you can come up to the mic and ask questions to the judges. So with that, we'll also adjourn our meeting for this time, but we hope to see you back at 11:30. Thanks, everyone.